So please keep in mind, again, that any questions you might have or comments in the chat will be a part of the recording. I appreciate everyone's attendance today, and I appreciate your interest in specifically in NAGPRA and its application on federal land in Hawaii. This is really the first webinar that I've done or training that I've done focused on Hawaii and the new regulations in Hawaii. So I hope you'll bear with me as we walk through what I've prepared for today. But I also hope that you'll be prepared to ask some questions. And when we do get to the Q&A time, I may pause or stop the recording if you be more comfortable asking questions in that format. I also want to say again that it is one of my delegated responsibilities to provide assistance on NAGPRA to any party, but specifically to federal agencies in carrying out the requirements of NAGPRA on federal land. So if you do have specific questions or concerns or issues that you've encountered in managing federal land, you're more than welcome to reach out to me directly and to my office, and I'll provide that contact information as well. So to get started today, I want to first share, well, I want to start actually by sharing additional resources because this webinar, while it's a start, it is not the only option for finding information, certainly, nor will it be the only opportunity to discuss these issues. If you're not aware, the National NAGPRA program over the last 10 months has done a series, a webinar series that has focused on various issues under the regulations. And all of those recordings are available on our events page. Again, you can go to the National NAGPRA program to nps.gov/NAGPRA, and at the very bottom scroll to events and get this list here. And that includes all of the recordings as well as the slideshows where that is included. And the slides that I have for you today are very much similar to what was presented in July in the deep dive into protection on federal land. I've maybe emphasized a few pieces of that slideshow, but for the most part, it remains the same. So if you want a copy of today's slides, you can find that here on the events page. In addition, I want to point out that on our webpage, we have fully revised the text to ensure that it relates to and explains the new regulations. And much of what you'll see in the slideshow today actually is taken from what's on our website when it comes to protection on federal or tribal lands. So I hope that everything that you hear today, you'll know where to follow up and find more information. Okay, so let me start by sharing now my slideshow. The chat is open if you do have questions as we go along, or if you are unable to see the slideshow, you should be able to let me know in the chat for the meeting. Okay. So what I wanted to do is to give just an overall understanding of the regulations, in particular related to federal land in Hawaii. Again, I have some specific emphasis here, but this is just a general overview. And I want to be sure that there's plenty of time today for questions or discussion. So please either put your questions in the meeting chat or write them down and we can address them at the end of the presentation. I will be able to let you turn on your video and audio and ask questions at the end. If you're not familiar with the NAGPRA regulations or the recent changes, I wanted to be sure that you understood that the regulations, which are found at 43 CFR Part 10, did go through a full revision. And that revision was published in the Federal Register at the end of 2023 and went into effect as of January 2024. It was a full revision of the implementing regulations with the objective to clarify and simplify the requirements, but it is in essence very similar to the prior rule. The revisions apply to all museums, as that is broadly defined, and to all federal agencies. When I describe NAGPRA, I like to describe it as really having two arms, two different regulatory processes. One arm or process is for the protection on federal or tribal land, and the other is for repatriation by museums and federal agencies. Today, we're only going to talk about the protection provisions of the regulations. We're not going to discuss repatriation by museums or federal agencies. Again, we have a lot of resources about that piece of the regulations. Today's focus is going to be the protection requirements on federal lands, and in particular, federal lands in Hawaii. In general, this part of the regulations and the law itself apply to all federal agencies, as well as the State of Hawaii, Indian tribes, and Native Hawaiian organizations. All of those parties have responsibilities for the protection of human remains or cultural items on federal or tribal lands. This section only applies to federal or tribal lands, as those terms are defined in the regulations, and I'll get to more of that in a minute. But again, in general, the objective of the law and the regulations in this section is to recognize that Native American human remains and cultural items belong, in the first instance, to lineal descendants, Indian tribes, and Native Hawaiian organizations, and not to federal land managers. That's the overarching principle of this part of the law, and again is echoed in the regulations, that Native American human remains or cultural items removed from federal lands in any state do not belong to federal land managers, but in fact belong to lineal descendants, Indian tribes, and NHOs. And the process that's built out through these regulations is to ensure that those rights are recognized and identified. And in fact, this section of the law, if you're not familiar with it, is titled Ownership, because it is explicitly about identifying the proper ownership of human remains or cultural items that are removed from federal or tribal lands. So I want to pause for a minute, and this is the only slide that I've added to this presentation today, to really talk a little bit more about what federal lands in Hawaii, what that means. And again, this is all based on the definitions in the regulations themselves. So there's nothing here that's not readily available to you through the regulatory text, but hopefully this will help you identify those pieces. So again, federal lands are defined by the law and the regulations as those lands that are not tribal lands. It's an important clarification in any state in the United States, but in particular in Hawaii, federal lands are not tribal lands. So that leads the question, what are tribal lands in Hawaii? Tribal lands, again, as defined by the Act itself and the regulations, tribal lands in Hawaii are all lands that are administered by the Department of Hawaiian Homelands. Again, that's a direct definition of tribal lands from the Act itself that we have reiterated in the revised regulations. There is a subset of tribal lands in Hawaii that these regulations really try to clarify, and that is the tribal lands of a Native Hawaiian organization, which is a subset of the tribal lands in Hawaii generally. And I'll get more into why we had to make that clarification in these regulations. It's probably one of the most significant changes in these regulations is that clarification of tribal lands of an NHO. But we'll get more to that when we talk about the disposition options. But for purposes of understanding what we're talking about today, again, federal lands are not tribal lands. Federal lands in Hawaii and any other state in the United States are those lands that are controlled or owned by the United States government. Whether or not you have responsibilities for federal lands as defined by NAGPRA is really a legal determination that needs to be made on a case-by-case basis. There's a lot that goes into determining whether you have responsibilities for federal lands, again, lands that are not tribal lands, and lands that are controlled or owned by the United States government. So I can't tell you broadly or even specifically what lands in Hawaii are federal lands, what lands are tribal lands in Hawaii. But again, I think hopefully these definitions help you to get to some of the identifications of these types of lands and how they're defined and how that relates to the specific case or circumstances that you might be engaged with. Okay, so the regulations and how they're structured in this subpart. Again, the effort for revising the regulations was to clarify and simplify these requirements. And that meant that some of the information from the old regulations has been reorganized. And in particular, 10.4, which is the general section related to protection on federal or tribal lands, has a lot of the information that used to be in other places in the regulations. And we'll talk more specifically about plans of action in a minute. But that was a piece of the prior regulations that was at the very end of this subpart, and it has been moved to the very beginning, again, to emphasize the requirement of a plan of action, but also that it does come at the beginning. So section 10.4 is the general applicable sections. 10.5 is regarding the discovery of Native American human remains or cultural items. 10.6 deals with excavation of Native American human remains or cultural items, and 10.7 is the disposition. So in theory, these are organized in what may be a chronological order, in that there may be a discovery, which leads to an excavation, which then leads to disposition. But of course, particular circumstances in any one case might mean that only some of these provisions apply. You may have a discovery of Native American human remains on federal lands, but you may not excavate those human remains or remove them, and therefore there is no excavation or disposition, but there's still requirements for the discovery itself. In addition, you may start the NAGPRA process with an excavation, knowing that there will be Native American human remains that will be disturbed and removed. And so you may start the process with the excavation. So just keep that in mind that while this is intended to be a sort of chronological process, it may not always follow that exact pattern. Okay, so again, the general requirements that can be found in section 10.4. And let me just add to the chat the regulations so that in case you are not familiar with where to find all of this in detail, you can have it here. And again, I'm walking through the sections under subpart B of the regulations. Okay, so again, the general requirements here are to designate an appropriate official. So the individual of the federal agency, the Department of Hawaiian Homelands, the Indian tribe, or the NHO that are responsible for carrying out these provisions should be designated as an appropriate official. There's also language in 10.4 in the general section about the coordination of NAGPRA with other laws like the National Historic Preservation Act. But again, a coordination, not necessarily that, and it definitely clearly states that compliance with, for example, NHPA does not mean you've complied with NAGPRA. But the biggest piece of this section is the plan of action or a comprehensive agreement. Both of those are tools that were in the previous regulations, but are clarified here in terms of what the process is to prepare that plan of action, or in the alternative, a comprehensive agreement. Please note that the difference between a plan of action and a comprehensive agreement is really who signs the document. A plan of action is required for a discovery or for an excavation. And that document must be signed by the federal land manager, the Department of Hawaiian Homelands, so by the federal agency or DHHL. But a comprehensive agreement is a broader document that would be signed both by the federal land manager or DHHL and the consulting parties. So that's where the agreement piece is the difference between the plan of action or the comprehensive agreement. The content of either a plan of action or a comprehensive agreement is the same in the process to achieve it. And that's laid out here on this slide in these 3 steps. Again, you can find this all in the regulations themselves, these 3 steps for developing a plan of action. And again, the plan of action is to initiate consultation, conduct consultation, and then to approve and sign that plan of action. I will stop here for a minute and switch screens. I apologize for the jumping back and forth, but I think it's best if I change here and share with you our template for a plan of action. Again, you can find this on our webpage. We have created a template for a plan of action. It's available under our policy page and templates. And again, it just reiterates the language from the regulations itself, but provides a way for you to fill in the information that is required by the regulations. I'm going to jump down to the actual plan of action. The first page are some instructions. Again, the plan of action just lays out the requirements of the regulation. There's certainly additional information or additional pieces of a plan of action that may be relevant to your specific circumstances. And in particular, I wanted to highlight the plan of action piece itself. And what the template includes is, again, just reiterates what's in the regulations themselves. But it's important to note that what the plan of action is, the content of this document, is really to describe an agreed upon plan for what will happen if human remains or cultural items are discovered. And that can include whether human remains or cultural items will be left where they are discovered, where they will be protected and secured in that location or in another location. Those are all parts of the plan of action and what the plan of action should determine. And again, remembering that these are informed and require consultation to complete the plan of action, there should be some effort to recognize and identify the preferences of consulting parties, especially where the consulting party's preference is to leave human remains or cultural items where they are found and for them not to be removed. That's an acceptable plan of action, and the goal here is to outline that in this document. Where maybe that is not possible, the plan of action should also describe then what other appropriate storage or treatment or handling of human remains or cultural items should be. And certainly the plan of action should describe how timelines and methods for identifying or notifying, consulting parties where there is a discovery or the need for an excavation. And then the last part of the plan of action is a plan for disposition. Again, if it's required, if there's a preference for leaving something where it is found, but that's not possible for any number of reasons, then in addition to storage and treatment, the plan of action should reflect the plan for disposition. This is intentionally vague. This is intentionally broad so that this tool can be customized and accommodate the specific needs of the federal land manager and the consulting parties. So I appreciate if any of you are sitting there frustrated that this doesn't give more direction or more clarification on what you as a federal land manager should be including in a plan of action. And that, again, is intentional to provide those opportunities for federal land managers as well as consulting parties to shape this plan of action into a document that satisfies, if not everyone's needs, at least tries to accommodate as many as possible. Let me jump back to my PowerPoint presentation. And I do see that there's a question in the chat, and I will definitely get to that soon, hopefully in the content of the presentation. But I do want to remind everyone again that my goal is to ensure that there's plenty of time for conversation and discussion. We'll just a few more slides to go through here. So there are clear requirements in the law that are reiterated in the regulations that require certain actions for a discovery or for an excavation. And the first requirement under 10.5 is on reporting a discovery. And any person who knows or has reason to know of the discovery of human remains must take some action. And that action is to report it to the appropriate official to protect and secure the discovery as much as possible. And then to notify the appropriate official in writing of the discovery. So these three requirements, again, are what is required in the law itself for a discovery. What we've tried to do with the regulations is make it clear how this works, what the process and the pieces of that requirement for any person to report a discovery. Now, you will know as well as I do that any number of people may find themselves on federal lands and may make a discovery. We often talk about a hiker who might identify something that is human remains or cultural items. And there is a requirement for that individual to report that discovery. And again, sometimes, especially in many parts of the Western United States, it's not always clear whose land someone might be on when they might make that discovery. Nevertheless, there is an obligation where it is federal lands or tribal lands to notify the proper appropriate official. I will say that for the purposes of our website, this chart is taken from the website. And on the website, the discovery, where the discovery is, these three links here, federal lands, tribal lands, and tribal lands in Hawaii, take you to a USGS online map tool called the Protected Areas Database. And it covers all levels of land and land protection. So not just federal and not just tribal, but allows you to search based on where you are using your cell phone to identify where you might be and what land you might be on. Although I'm not certainly an expert on lands in Hawaii, I did share this resource with the Office of Native Hawaiian Relations in the Department of the Interior, and they felt that it was a good resource as well for identifying protected areas on the islands in Hawaii. So again, just for ease of use on the website and for this requirement for reporting, we've linked to this Protected Areas database. In addition to reporting a discovery, there are also requirements to stop an activity that is connected to a discovery. This is, of course, critically important where a discovery is related to an activity that is somehow permitted or authorized on federal land, and that again could include construction, mining, logging, or agriculture, as well as many other ways that our federal lands might be related to an activity. And in those cases, the activity must stop when there is a discovery. And again, there's an obligation for the person conducting the activity to report the discovery and to report in writing. This idea of stopping work, especially on federal lands, we received quite a few comments on this issue in the proposed regulatory changes. We received comments on both sides. We received some comments that asked that we extend this timeline or make it an indefinite timeline for work stop. In addition, we received comments that objected to allowing any time beyond the 30 days that is identified in the law itself for a work stop on federal land. In response, the regulations provide that the minimum number of days that work might stop is 3 days to achieve that reporting requirement. But works could stop as long as 60 days to carry out the requirements for responding to a discovery and certifying that the activity can resume. So again, depending on circumstances, this timeline is flexible within the 3 to 60 day window. However, we have provided the 60 days, so more than the 30 days that's identified in the law, that allows for that opportunity for a federal land manager to ensure there is a plan of action in place, as well as to ensure the security of the discovery itself. I'll have a slide towards the end that will give you some more direction on how you can read more about that conversation that was a part of the regulations. But the basic requirements in responding to a discovery is that the appropriate official must respond within 3 days. Within 30 days, must approve and sign a plan of action. And then within 30 days, send a written certification. So again, 30 days of the discovery, a written certification that identifies a date that must be no longer than 30 days after the date of that letter. That gets you the full 60 days there, in which an activity may resume. For purposes of an excavation, when an excavation is required on federal land, there is a requirement on federal or tribal lands for the federal agency to authorize the excavation, as well as to ensure there is a plan of action. And in some cases, a permit under Section 4 of ARPA may be required when an excavation is on those lands that are also applicable under ARPA. The last section of these regulations is on the disposition. And while I've used this slide before, I've highlighted the parts of this that are particular to Hawaii. And I think that this may go to the question that we've got in the chat as well. And I'll address more directly. So when a discovery or an excavation occurs on federal land, the law itself lays out the priority order for who receives those human remains or cultural items. The first priority order is a lineal descendant, if there is one, for human remains or associated funerary objects. The second priority is the Indian tribe or NHO from whose tribal lands the human remains or cultural items were removed. If you recall at the beginning, when I mentioned that there is a subset of tribal lands in Hawaii that is the tribal land of an NHO, and that is a defined category in the revised regulations, that is in direct response to the requirements here in the law that a Native Hawaiian organization could have tribal lands and that they would be in the second priority after a lineal descendant for any human remains or cultural items that were removed. After that, the next priority is the Native Hawaiian organization with the closest cultural affiliation. And that's where the question in the chat comes up. And I'll get to that in a minute. There is no application in Hawaii for the fourth priority here because the final judgments of the Indian Claims Commission do not extend to Hawaii. However, there is a fifth category that is important to recognize and identify, and that is that when human remains or cultural items removed from federal lands are unclaimed, then there is an opportunity for a Native Hawaiian organization to request transfer of those unclaimed human remains or cultural items. We have provided in the regulations a step-by-step process for disposition. And those steps are outlined here. But again, you can find these on our website. You can find them in the regulations themselves. These steps are, again, to identify and inform consulting parties of the human remains or cultural items. There is a requirement for publication of a notice of intended disposition. One of the changes in the regulations is that notice must now be published by my office in the Federal Register, where in the past, these notices were required to be published in a newspaper. After a notice is published in the Federal Register, then there can be a claim for disposition, a response to that claim, and then the final step in this process is, again, a new piece to these regulations, and that is a disposition statement that finalizes the process by issuing that disposition statement to both the claimant as well as a copy to my office. There is, and we recognize the potential for there to be human remains or cultural items that were removed from federal lands after 1990, after the passage of NAGPRA, and the establishment of these new regulations in 2024, and where disposition has not been completed for those. We have added a requirement, which is now past due, but there is a requirement for federal agencies or DHHL to send to inform consulting parties of those collections, or I'm sorry, of those human remains or cultural items removed from federal or tribal lands, and then to continue the disposition process. So we sort of see this as a catch-up provision for anything that might have been removed from federal lands between 1990 and 2024 to ensure that the disposition has been followed through and completed. This goes back to, if you recall at the very beginning, the intent of Congress with this ownership section, which is that federal lands managers do not have ownership of human remains or cultural items that are removed from federal lands after November 16th, 1990, but rather that ownership is with lineal descendants, Indian tribes, or Native Hawaiian organizations. And there is a requirement here for federal agencies to ensure that that has been completed. As I mentioned, there is an opportunity for unclaimed cultural items. I think that there is a less likelihood for this to apply in Hawaii generally because of the requirement for cultural affiliation, which I'm going to get to. And then this slide shows where, in particular, in the final rule, you can find some of the comments that are specific to these sections of the regulations that we've discussed, and it might be helpful for a deeper understanding or a further understanding of some of what I've explained. Certainly, if you want to look more at our comments and responses on the work stop requirements on federal land, there are many comments that are related to that. Let me see if I can get a link to Yes, so let me give you a link to the final regulations themselves. Put this in the chat in case you don't have it at the on your favorites bar the way that I do. And you can easily navigate this. It's a very long document, but you can navigate this and find the comments that you're specifically interested in, really by using the number followed by a period, and it should jump you right to that comment. So hopefully this is helpful. And again, you can find these slides on our events page. These are the same slides that I've used in previous presentations. So the last thing that I wanted to be sure I addressed is the issue of cultural affiliation, because that is significant in Hawaii in particular. And let me share my screen again. Again, here I wanted to share with you the regulations themselves. This is the text of the regulations from the section on cultural affiliation, which I will also put in the chat for your ease of reference, and it's related to the very first question that we have. And the question, which you can read in the chat, but I'll go ahead and read out, is that while I said that the NAGPRA regulations were revised and are similar to the previous regulations, would I agree? The question is, would you agree that the revisions to this section, 43 CFR 10.3 E2, and in particular, the clauses related to the priority order for Native Hawaiian organizations with the closest cultural affiliation is different and not what was in the previous regulations? The question is, who wrote this and gave input to the National NAGPRA program, specifically on the use of the APUA as a category for priority order here? And could there be a discussion to figure out how to apply this section? Absolutely. There needs to be more discussion about how to apply this section. And that discussion needs to be primarily with the consulting parties. I want to say that first of all. And second of all, I want to be clear that while we're looking here at a very specific priority order for Native Hawaiian organizations, this only occurs in the cases where there are competing claims for disposition. So again, remembering that there is a lot of work and consultation that leads up to the claim for disposition. The plan of action itself, consulting parties are involved with, and that's a broad list of consulting parties. And then as you go through the process, you inform consulting parties where there is a discovery. You then publish a notice of intended disposition that identifies those parties with priority. And the parties with priority would be those Native Hawaiian organizations with cultural affiliation. Following publication of a notice, where there are claims for disposition and competing claims, meaning that they are multiple parties who are claiming disposition, who are culturally affiliated, but who do not want to join a request or a claim from someone else. That's when this piece comes into play, when a federal agency must determine who is the closest culturally affiliated Native Hawaiian organization. This piece of the regulations was important to add because, as many of you are probably very aware, there are often competing claims from Native Hawaiian organizations, and we felt there needed to be guidance provided on how to determine the closest culturally affiliated Native Hawaiian organization. This was not in the previous regulations, this detailed information. What was in the previous regulations was a requirement for federal agencies to determine the closest culturally affiliated NHO. This is not new. This requirement for a federal agency where there are competing claims to make this decision. We are hopeful that what we have here, and this was largely provided by the Office of Native Hawaiian Relations, as well as through consultation with Native Hawaiians on the draft regulations. This can help where there are those competing claims for disposition, and the federal agency has to make that decision of who is the closest culturally affiliated NHO. And so I want to step back for a minute here to this section, again, in general, about determining cultural affiliation. And the objective here and the requirement here for a federal agency is to identify the Native Hawaiian organization with cultural affiliation. And only in cases where there are competing claims for disposition would this section in E2 apply. We have, again, stressed in this section that joint claims for disposition are possible, and we have seen in other places that process of a joint claim for disposition resolves any need to identify the closest culturally affiliated NHO. But where there are competing claims, then what this section does is provide for a priority order based largely on the location of the human remains. It does start here with 2 priority orders for an ohana. Again, we have defined the term ohana in the regulations to give additional information here, and to respond to the other question that's in the chat. In this case, an ohana would be actually, I'm going to pull up the definition because I think that's where we included. It is not intended to mean a lineal descendant. This is separate from a lineal descendant, which again, you'll remember a lineal descendant has the priority over a culturally affiliated NHO. But an ohana here, as we've defined it in the regulations, means a group of people that are not asserting to be lineal descendants, but do comprise a Native Hawaiian organization. And so those are the first 2 priorities here, are those ohana that can, again, are not lineal descendants, but are a Native Hawaiian organization that has a closer cultural affiliation to the human remains in a competing claims process. The question in the chat about lineal descendant goes to, again, I think I would refer you to the definition of a lineal descendant, and maybe I'll jump here to the definitions to assist. Let's see. We have provided a definition of lineal descendant, and that definition excuse me, I want to make sure I was sharing the correct screen. A lineal descendant here is a living person that traces ancestry either by means of a traditional Native American kinship or a common law system of descent to the individual whose human remains are subject to this part. So where the individual whose human remains or cultural items is known, the previous individual, the lineal descendant is the living person that can trace ancestry to them. So the question was, could I give an example of when you would know that there is a direct lineal descendant? It does not require DNA, as the question asks, but it does require knowing who the earlier individual was. And sometimes DNA is a way to know the previous individual, but more often there are other ways of identifying the previous individual, the deceased individual, either by name or by a burial location, can be ways in which lineal descent can be identified, provided that those human remains can be identified as an individual, and then the living person can trace a connection to that earlier person. Okay. All right. You're looking for a real world example of lineal descent. I can give you some. I'm not sure that we have, well, actually, we may have some in Hawaii. We certainly have lineal descendants that have been identified in a notice. I'm not sure we have any that are identified in a notice of intended disposition, although we may. I'm not as familiar with the content of those when they were published in newspapers as I am now. They're being published by my office in the Federal Register. Let me see if I can abstract some specific cases. Certainly, there are cases where a burial site is a burial of a known individual. So it is known that this person is buried in this location. Maybe that's known through a headstone, often not. Maybe it's known through the location of the property or the burial place. This is this individual, this person, and their body is buried in this location. Or these 3 or 4 people are buried in this location, and they're all related to each other. That then could be a lineal descendant who could be identified as connected to either one or all of the people that are buried in that burial location, because the identity of those people that are buried is known. I know that I'm not giving you a very direct answer, but I think that lineal descent requires obviously consultation with those living persons, and needs to be identified by the lineal descendant themselves. They are the ones that can provide that information to show that lineal descent. I guess I can give you a concrete example outside of the Native American context, which I think probably most of us can relate to. My family has a burial site, a cemetery on private land in Missouri, where my family had farms for hundreds of years. And some of those burials have grave sites and some of them don't. I'm sorry, some of those has headstones and some do not. But I'm a lineal descendant to all of the people that are buried in that graveyard because it was my family that was buried there. So I don't know if that gets there, but certainly cultural knowledge is important, and the lineal descendant needs to be central to that discussion about identifying if they are a lineal descendant. Cultural knowledge could be sufficient. Again, the key here is the identification of the earlier person or people that are buried in a location. And again, that can sometimes be the location can provide that information. All right, another question here about what information or format should a claim for disposition be, and can a federal agency support the claimant in drafting their claim? Absolutely, the federal agency can support the claimant. The content of a claim is specified in the regulations. The requirements for a claim for disposition are really that the party is identified in the notice of intended disposition. There doesn't need to be much more than that. What is required, and again, where the federal agency has the responsibility here, is to identify who has priority in this priority for disposition, and which Native Hawaiian organizations have cultural affiliation, and maybe even the closest cultural affiliation might be determined in this priority piece, and that would be published in the notice of intended disposition. So really, the federal agency should put its emphasis and its effort into that notice of intended disposition and in identifying who has priority for disposition. After that, making a claim for disposition is simply a matter of saying, I'm listed in the notice and I make this claim. Alternatively, of course, somebody who's not listed in the notice could make a claim for disposition. That is a part of the process and actually the reason for publication of a notice. And so in those cases, there may be a need to I would say you would need to be cautious about how you might support somebody making a competing claim in these kinds of circumstances. Again, especially if you are the federal agency that then must make the decision about who is the closest culturally affiliated party. So I'd say there's need some caution there on the federal agency's part about their involvement when it comes to a competing claim situation. Hopefully that answers the question. I just wanted to, again, highlight a couple of resources, and then I'm going to stop sharing my screen so we can continue to have this discussion. I think I've got this scheduled for another 40 minutes here. We do have a series, a number of templates available on our website that relate to all of these pieces, and I encourage you to take a look at this, especially including a notice of intended disposition. I'm going to stop sharing my screen. There we go. And I want to provide an opportunity for anybody to ask a question, have a conversation, whatever you would, however you'd like to engage here. Why don't I stop the recording?